So maybe a bit much.
And we on YouTube with it. Shout out to all my
The record, on the record in the matter of the people of the state of Michigan versus Brian Keith Blaylock, file number 24-01169, counsel appearance.
Your Honor, good morning. Assistant Prosecutor Bill Crino on behalf of the people of the state of Michigan.
Good morning, Your Honor. Dwayne Silverthorne from the Office of Public Defender on behalf of Brian Blaylock, who I see is appearing from the Union County Jail.
Okay, today was the date and the time that was scheduled for a probable cause conference. The matter is scheduled for a preliminary examination May 8th at 8:30 in the morning in person at the court. My understanding is that there is right now a request to waive the timeline.
That is correct, Your Honor. It comes from the defense.
Okay, and what is the basis of the request?
But we don't have an autopsy report, and I don't know that I've ever run a preliminary examination without having adequate time to look at such report. There's additional discovery. This is a very serious charge. I've discussed this with Mr. Blaylock. He understands that I have a need to be prepared, and he will also consent to it.
Okay, Mr. Blaylock, can you hear me?
Oh, yes, I can.
Okay, Mr. Blaylock, in this matter, you are set for a preliminary examination on count 1 of homicide, open murder, count 2, weapons carrying concealed, count 3, weapons, firearms possession by prohibited persons, and count 4, weapons, felony firearm. There is a third or subsequent offense notice attached, or count 5 of weapons, felony firearm, also with a third or subsequent offense notice, and a habitual offender 4th offense notice. You have the right to have a preliminary examination within 21 days of the date that you were arraigned. You were arraigned on this matter on April 19th by Judge Flores. And your matter again was scheduled for May 8th. Due to the fact that your attorney has not received all the discovery that he needs to help you formulate your defense, are you willing to waive the timeline so that this matter can be reset beyond the 21 days?
Yes, yes.
Okay, anybody threatening you to get you to do that?
No.
You're done, no more. All right.
July 11th. How long is this exam going to take?
Your Honor, thank you. We anticipate that we can conclude this exam in either one morning session or one afternoon session.
July 11th at 9:30. Any additional matters for the record today?
Your Honor, thank you. The people would also so waive our right to preliminary examination within 21 days here. We believe that good cause exists as articulated by the defense because they are awaiting the autopsy report, which will be important in this matter, as well as additional information through discovery. So we have no objection to the adjournment. Your Honor, the July 11th date, currently, my understanding is I may be out of town July 11th. However, we can leave it on until I can confirm that. Is there possibly a date at the end of June, Your Honor, or we can deal with it accordingly down the road, but it's just checking before we go off the record. Is there maybe a later June date, or is that the first available date?
That's the first available date.
All right, that's fine, Your Honor. We'll get it covered by my office, whether I'm available or not. So we do appreciate it. Thank you.
No problem. Any additional matters for the defense?
No, Your Honor. Thank you.
Thank you. You're all set for today, Mr. Blaylock.
Thank you, Your Honor.
Thank you.
Good day, Your Honor.
Okay, Amon failed to appear. Okay, should bring Sean. Yes, you can't put him on until 10, that's what Jackson, on the record in the matter of the people of the state of Michigan versus Trachorius Dodd Brown, file number is 24-01188, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Trachorius Dodd Brown, who is appearing separately from the Ingham County Jail.
I don't have a slide. Going off the record. Yeah, we off the record. I don't have this file yet.
Hey. Sent to 54B, wrong.
Oh, that's unfortunate. You're all here at the country club hanging out, huh?
Yeah, it's not exactly.
While everybody else is out here
Working.
grinding out.
They keep you kind of busy.
Which one did you said for B?
Well, you've been handling misdemeanors, right? Or missing phone.
Yeah. I've been very busy with driving while licenses.
I know, you gotta be
Dogs are not
swamped over there.
licenses.
Ingham County's cracking down on those dog licenses, I'm gonna tell you that.
Well, we want
Not dog bites.
to dragon chuck, yeah, struck down the dog bite statute.
This is deciding whether or not we're going to
No,
appeal
I thought you
that.
guys were.
Oh, then that might have happened. And I was
Yeah.
What was the basis?
Sorry.
Go back on that.
Yeah, but should we take it at the most thin-skinned version?
I know. Back on the record in the matter of the state of Michigan versus Trachorius Dodd Brown. Counsel your appearances again.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant, Tricorius Dodd Brown, who's appearing separately from the Ingham County Jail.
Okay, I have this matter scheduled today for a probable cause conference. There also was a contempt hearing scheduled. Are we continuing to examine this?
Your Honor, we would like to continue to exam, but at this time, I am still waiting on certain body worn camera evidence there, and there is a new case that he has set for PCC next week and a preliminary exam the week after that. So it's my understanding that Mr. Dodd Brown would waive the timeline so that we can just have the preliminary exam adjourned from next week to the other in the bond violation. Well, no objection to that request.
Thank you. Mr. Dodd Brown? Hi. You understand that you have the right to have a preliminary examination in this matter within 21 days of the date that you're arraigned. And due to the fact that your attorney is still waiting on some evidence, are you willing to waive the timeline so this matter can be reset beyond the 21 days?
Sure.
Anybody threatening you to get you to do that?
The police, I just want to know.
Any promises being made to you to get you to waive the timeline?
No.
Okay.
May 17th.
May 17th at 8:30. We'll reset the
Alright.
contempt hearing to that same date and time. Any additional matters for today's record?
Nothing for the people.
Nothing for defense.
You're all set, sir.
Or.
Mr. Abbott, step out.
Yes.
Ms. Wanji is here for Alvarez. They not put him on yet. Who's on the Motorola Moto G stylus?
That's me.
You think I can
The
identify
Moto
you?
G stylist.
So you think I know who me is?
No, I don't think you know. My name is Whitney Lynn Ransom. I'm on a Moto G stylist.
Thank you. Can you please turn your camera on?
Yes. Now,
That's Mr. Palmer's client. She's got low bandwidth. I don't know if our signal is good. Mr. Carter, your client, they said they can't put him on till 10 for her. This is a woman. They can't put him on till 10.
All right.
We're waiting for Mr. Hillborn
Yes, Your Honor, he's in custody.
downstairs or? Oh, okay, we can bring him up. Ms. Schroeder, you're here with Bledsoe?
Yes, Your Honor.
On the record in the matter of the people of the state of Michigan versus Juan Bledsoe and file number 24-01187. Council appearance.
Assistant Prosecutor Pete Petrosky on behalf of the people.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Bledsoe.
I have not seen Mr. Bledsoe. Have you seen him?
I have not, Your Honor, and I have not had luck getting a hold of him either.
Okay, looks like his tether was also cut off on the 29th for non-payment. He failed to enroll in pretrial services. So it should be sworn in a remand. We'll also set it for a bond violation. Any additional matters for today's record?
Nothing for the people.
Nothing but defense.
What's your name in the jail?
Derek Jones.
Did you speak to your attorney?
No, ma'am.
Have you ever spoken to your attorney?
Yes, ma'am.
Okay. He indicated that you were going to continue to your exam. We'll see you next week for your examination, okay?
Yeah.
Thank you.
We're gonna be leaving out preliminary exam, but I had given Mr. Rouse his copy of his discovery.
Okay, on the record in the matter of the people of the state of Michigan versus Justin Rouse, file number 24-01138. Appearance for the record.
Assistant Prosecutor Pete Petrosky on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Justin Rouse, who was present and standing tonight.
How are you, Mr. Rouse?
Yes, ma'am.
How are you?
Oh, how are you? I'm fine, thank you.
Okay,
How about
today,
yourself?
I'm doing well, thank you. Today was the date set for a probable cause conference on one count. Weapons, firearms, possession by prohibited person, count 2 weapons, felony firearm. And then there's a misdemeanor, open alcohol, and a habitual offender second offense notice. Matter is scheduled for preliminary examination in person at the court next week, May 9th at 9 o'clock in the morning, and we're continuing to exam.
Yes, Your Honor.
Any matters we need to address on the record today?
Nothing for the people.
Nothing for defense.
Do you have any questions for the court?
No, ma'am.
We'll see you next week.
All right, thank you, ma'am.
Thank you. Ms. Donnelly, anybody else here?
I'm supposed to have Mr. Alexander. He said he was gonna appear by video at 9:30, but I don't see him yet. So I'll make a phone call.
Okay, sounds good.
Mr. Mills is gonna be filling it for the PCCs.
Sounds good.
If necessary.
Yeah, I
Just talk
Mr.
about it.
Ransom is
Okay.
here. Okay, on the record, in the matter of the people of the state of Michigan versus Benjamin Hillborn, file number is 24-00264, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. Attorney John Abbott, with the Public Defender's Office. With Benjamin Hillborn, he's standing to my right.
How are you, Mr. Hillborn?
I'm doing good, Your Honor. How about yourself?
I'm doing well, thank you. Okay, let's see, today was the date that was set for a sentencing. And then there is a bond violation contempt hearing. I do have a pre-sentence report. It was prepared on April 26, 2024. Counsel, did you get a copy?
Yes, I did, Your Honor.
Yes, I did, Your Honor.
I don't have anything on the bond violation.
I'm sorry?
I do not have any information regarding the bond violation.
It's arraigned on March 18th. It states one of his bond conditions was that he wasn't to enter 6200 South Pennsylvania. And the allegations are that was that he entered them.
Thank you.
Okay, and he stood mute at the time of that exam, and I mean, sorry, at the time of that arraignment, and it looks like he was referred for a CATS eval at the same time. Nonetheless, as to the pre-sentence report, do we need to make any changes, corrections, or updates?
None for the people.
Not that we identified. Thank you.
Okay, we can make allocution.
Thank you, Your Honor. As the court is at this point well familiar with Mr. Hillborn, and the pre-sentence report in this report is similar to other pre-sentence reports we've read about Mr. Hillborn. There continues to be some mental health issues. He tells me today that he's receives a shot once a month in jail, and he's which does quiet the voices, and it's less frequent, less startling. So he's in good shape when he's on his meds, and he's not. The case in these cases, frequently when he spends time in jail, he loses his disability payments, and he's broke when he gets out. And he understands, and we discussed it. He clearly does understand that stealing things is wrong, and stealing things is why he ends up in jail. And I should also mention to the court that he's got an arraignment scheduled in 54B and another arraignment scheduled in 54A. Okay. One on the second, and one on the
9th and one on the 16th.
Arraignments for what?
Retail fraud.
retail frauds that occurred prior to his arrest date on this.
One on December 8th and one on January. Like right about the beginning of January.
He's being held on anything other than this?
Not that I'm aware of, other than those two.
Just those are the two arrangements.
Yeah, but they're not holding you, so if I dispose of this with credit time served, he's gone, he's not been arraigned. And what's the likelihood of us seeing him for an arraignment?
Well, Your Honor, I discussed housing with him prior to our appearing in the court this morning, and he says that he's working with people at CMH on finding him an alternate location to live. He was living in a group home. That location is not currently available, but they are actively pursuing the question of housing. At this point, Your Honor, I don't have an address to give the court.
Oh, okay, let me go off the record and get the other file he needs to be arranged on. Let's see, Ms. Donnelly, your other client didn't appear, correct?
Yes, Your Honor, I'm trying to get a hold of him. I had contact with him yesterday. He was gonna appear by video because he lives in Weston, down southeast of here. I don't know what happened. He hasn't reached out. I would just ask if there's a possibility of 48-hour hold in case he does. Because it's his first failure to appear.
I'll hold it till the end of the day. He's on parole, it says, in Lenawee County. So
Yes.
I don't know if maybe he's running late,
Yes, that's what I'm hoping.
but if you hear from him, we won't enter it. I'll hold it to the end of the day.
Okay, thank you.
Thank you. Let's see, Juan G, good morning.
Good morning, Yona.
Do you have Jon Summers with you?
He's not
Not here yet, a little early.
here.
Okay, what about Alvarez? He's on the Zoom.
Yes.
Okay, did we need to go on the record or are we continuing to exam?
We need to go on the record.
Okay, we'll do that one that, I don't have a vote for that right now. Some music.
Got the podiums and stuff set up this morning when I was walking in. Oh.
Okay, on the record, in the matter of the people of the state of Michigan versus Benjamin Hillborn and file number 24-01202. I'll take your appearances, counsel.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. Attorney John Abbott with the Public Defender's Office representing Mr. Hillborn. He is standing to my right.
Okay, Mr. Hillborn, this is a new file, retail fraud second in count 1, alleging that on or about December 8th, 2023 at 6200 South Pennsylvania, City of Lansing, Ingham County, State of Michigan, you did allegedly, while Meyer was open to the public, steal property of the store that was offered for sale at a price less than $200. There's a second or subsequent offense notice that alleges and states, and it further appearing that on May 23rd, 2011, the defendant was previously convicted of violating retail fraud second degree under MCL 750.356D in the 54A District Court in Lansing. Therefore, this violation of MCL 750.356D4 constitutes retail fraud in the second degree, contrary to MCL 750.356D. It's a misdemeanor. Maximum penalty is 1 year in jail and or $2,000 in fines, or 3 times the value or difference in the price of the stolen property attempted to be obtained, whichever is greater. Do you understand the charge and the maximum penalty, sir? You have the right to be represented by an attorney. You are represented today by Mr. Abbott because you're present on another matter. And he will represent you for the purposes of your arraignment only on this file, but you do have the right to have an attorney represent you at each stage of the criminal prosecution on this new charge. And you have the right to be represented by an attorney if you're questioned by law enforcement, okay? If you can't afford to hire an attorney, you can make a request to have the Public Defender's Office appointed to represent you at the expense of the public. Did you want to make that request today?
Yes.
I'll note that in the file.
I'll fill in the form this afternoon.
Very good. I'll enter a plea of not guilty on your behalf, but I will advise you that you do have the right to plead guilty. You can plead not guilty or you can stand mute. If you stand mute, the matter will continue all the way through to your jury trial, okay?
Yes.
You have the right to jury trial in this matter, and you have the right to the presumption of innocence. You're innocent until proven guilty. You have the right to require the prosecution prove your guilt at your jury trial by proving each element of the charge of retail fraud second degree beyond a reasonable doubt. You have the right to see, hear, or question any other witnesses that they call to testify against you. You have the right to remain silent at your trial and not have silence be used against you. You can waive your right to silence and testify on your own behalf. You can subpoena witnesses to testify for you or present evidence at trial that you believe show a defense to the charge being brought against you. Do you have any questions about those rights?
No, Your Honor.
Okay, and you don't have a current address, is that correct?
That's correct, Your Honor.
Nor do you have a phone number?
You can use my dad's number. That's the best way to get a hold of him. It's 517-819-9270.
May 14th. May 14th at 1:30? Yes. Okay, you'll see me May 14th at 1:30, okay?
Okay, Your Honor.
We'll get you a copy of your notice to appear. Bond will be set in the amount of 20,000 personal recognizance. While out on bond, you have the following condition. You're not to be at 6200 South Pennsylvania, okay?
Yes, Your Honor.
You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm or any other dangerous weapon. You're not to use drugs or alcohol without a valid prescription. You're not to travel outside the state without prior approval of the court, okay?
Yes, Your Honor.
Do you have any questions about your bond?
No.
As to file number 24-00264, I'll dismiss the bond violation as it's connected to this new case and credit and time served. To continue with your treatment, you're staying current on your medication and working with community mental health, okay?
Yes, Your Honor.
Do you have any questions?
No.
Are you gonna remember to be here on your next court date?
May 14th.
Very good. Any additional matters for the record?
No, thank you.
Nothing for the people.
Thank you. You're all set for today, sir.
Thank you, Your Honor.
Is there someone behind my computer? Okay, who was it? Oh, is there an attorney back there?
No, no.
Oh, okay. Where did Ms. Wangchi go?
I'm not sure.
Mr. Milks, he's gonna do ransom for Palmer, correct?
Yeah,
Ms. Milks, you doing ransom for Palmer? Okay, on the record in the matter, the people of the state of Michigan versus Whitney Ransom, file number 24-01198, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Ransom. I am standing in for Robert Palmer, the attorney of record. He's in a prelim right now. And is in order for efficiency purposes, so she doesn't have to wait on it. I will cover it for today, Your Honor.
Okay, today is the date set for a probable cause conference. Ms. Ransom has a preliminary examination here in the court in person, 9:30 in the morning, May 9th. Are we continuing?
That's my understanding that it will be continuing to exam.
Mine as well, Your Honor.
Ms. Ransom, do you have any questions for the court? You have to unmute because we can't hear you.
No, ma'am. Your Honor.
Okay, we'll see you in person next week for your examination. Any additional matters for the record?
Nothing from the people.
Nothing from the defense. Thank you, Your Honor.
Thank you. You're all set, ma'am.
Thank you.
On the record in the matter of the people of the state of Michigan versus Kane Alvarez, file number is 24-01053. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. May I need to warn you from the public defender office for Mr. Kane Alvarez.
Mr. Alvarez, can you hear me? Okay, today's the date set for a probable cause conference. This matter is scheduled for preliminary examination, May 9th, 9:30 in the morning, in person at the court on count 1 of unlawful imprisonment, count 2, police officer fleeing second degree under the vehicle code. Count 3, aggravated stalking. And then there is a count 4, domestic violence, which is a misdemeanor, and a habitual offender, 4th offense notice. Are we continuing to exam?
We can't, our office is conflicted with that. Trying to find him another attorney.
Okay. So what I'll do is I'll treat next week as another probable cause conference.
Yes, Your
No
Honor.
witnesses.
Thank you, Your Honor.
And I'll adjust the timeline at that point, okay?
Thank you.
Do you have any questions for the court, Mr. Alvarez?
No, not at the time, no. Kind of wish that we could have just ran, kind of wish that we could have just ran everything and got everything over with right now, but.
I just need you to speak up a little louder for me, please.
I said, not at this time, Your Honor. I kind of just wish I could have got everything over with right now, but I have to figure out new counsel and everything.
Absolutely. So we'll see you next week in person. Well, they'll probably convert that to a Polycom. He doesn't need to come in person. I will see you next week via Polycom for another probable cause conference.
Yes, Your Honor.
Thank you. You're all set.
Thank you.
Yeah. Those not on. You have Jon Sherman with you? On the record in the matter of the people of the state of Michigan versus John Edmund Sherman Jr., file number 23-03161, counsel appearance.
Excuse me, Your Honor, that's one of Mr. Piper's cases. I believe he's in the hallway. Mind if I go grab him real quick?
You believe he's weird?
I think he's just down in the hallway.
Sounds good.
Thank you. My apologies for the inconvenience.
Off the record on that matter, on the record in the matter of the people of the city of Lansing versus John Sherman, file number 23-01952. Counsel, you're gonna put, well, I think this is because he didn't pay his ticket. That's what this is. Mr. Sherman, you have had a driving while license is suspended. Looks like you pled guilty to an amended charge. I think it says impeding. You accept the responsibility to impeding traffic. You had a fine of $130. You were given 90 days to pay the $130. However, you didn't make that payment. There was a show cause set for February 1st. Never appeared. Nope, it was February 20th. You never appeared. Your balance is $156. Are you paying that today?
Yes, ma'am.
You leave here, we'll get you to the criminal traffic window so you can make that payment on it.
Mr. Piper's on the record, but he said he'll be like less than 5 minutes, and that it's gonna be
Off the record. your name, sir?
Lake Swan Jackson, 677-355.
Thank you. On the record, in the matter of the people of the state of Michigan versus Lake Swan Tyrese Jackson, file number 19-02673, council appearance.
Assistant Prosecutor Victor Drosky on behalf of the people.
Please the court, David B. Carter Jr. on behalf of Mr. Jackson. Appears to be polyconned in from a correctional facility, MDOC.
Correct. He's present at the Saginaw Correctional Facility. Today was the date that was set for a probable cause conference on an uttering and publishing. It is scheduled for preliminary examination May 9th at 8:30. Are we continuing to examine?
Your Honor, I'd respectfully request that the preliminary exam be treated as another PCC. I was just conflicted out. I have yet to receive the discovery nor make contact with Mr. Jackson.
Okay, I'll note that in the file. We'll treat next week as another probable cause conference. No witnesses are required to appear. We'll let the Department of Correction be made aware that he can appear via polycom next week versus being written from Saginaw.
Thank you, Your Honor.
Any additional matters for today's record?
Nothing from the people.
Nothing.
Thank you. You're all set, Mr. Jackson. Your attorney will be in contact with you. Thank you. Mr. Jackson, you can let the corrections officer know you're all set.
Ready to go. Gotta come get me. You know. I'm done. Yeah. That was quick. You say what's wrong?
of Michigan versus Daquan Marquise Bledsoe, file number 24-01187. Council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
And good morning, Your Honor. Jared Austin, filling in for Counsel of Record Aaron Schroeder, appearing for today's purposes on behalf of Mr. Bledsoe, who's present to my right.
Thank you. Mr. Bledsoe, you're supposed to be here at 9 o'clock.
Yes, I'm slept.
Sorry?
I said I got out at 5 in the morning. Sorry.
Got out of what?
Work.
Why is your tether cut off?
I didn't know it needed to be charged, you know, when you plug it up, I mean, when you plug it up while you're sleeping, you toss and turn, it's easy to just, the cord is easy to come out.
That tells me that it's cut off because you didn't pay it.
Oh, yeah, I didn't know I was going there and pay it.
You didn't know you were supposed to enroll in pretrial services either.
I went up downtown to see my PO, and told him about what happened.
I didn't ask you anything about your,
Oh,
Yeah.
oh, sorry.
you're on probation?
Yes.
I didn't ask you anything about that. I said you didn't enroll in pretrial services. You have 2 bond violations and you were late to court. Your GPS tether has been cut off or off since the 29th. It says on the 25th, an investigator from pretrial services attempted to contact you for enrollment in pretrial services, and they left you a voicemail requesting you to return the phone call. So even if you forgot, you got a voicemail. Then on the 29th, they called you again because they were notified that your tether was cut off due to non-payment. And so you can't be monitored safely. So you're in violation of your bond conditions. I have to remand you so that your bond conditions can be addressed.
I'm sorry. I thought pretrial services was a part of going to see the probation officer. That's what I was doing.
Pretrial services has nothing to do with you being on probation.
Oh, okay. Sorry.
You would have received information on how to contact pretrial services when you were arraigned on this. You were also advised that you were supposed to be on GPS tether and you knew your tether wasn't working.
No, I didn't know.
The tether company didn't contact you?
No, that's what I'm saying. This is my first time being
What's
on
your phone number?
917-962-3770.
The tether company contact you at that number. Pretrial services has contacted you at that number. Your attorney has tried to contact you as well, and she reported this morning when you were not here that she'd not been in communication with you. So that's another bond violation. You're not doing what you're supposed to do, and you're doing what you want to do.
No, I'm sorry. I didn't mean to.
And you can say sorry till you blue in the face. When are you gonna pay your tether?
Today, I paid today. I didn't know I had to pay. I had to go up there and pay.
I'm gonna remand you to have it paid. I can't monitor you. You were released on tether. We're not monitoring you right now. No, and you're not even contacting pretrial services.
I'm sorry.
What are you on bond for? I mean, what are you on PO for? Probation for?
A felony, B&E.
You're on probation at 30th Circuit?
Yes. Yeah, I'm on probation already. I wouldn't just not think of it. I said I know the pretrial service. I went there last week.
Is your phone working?
Yes.
Why aren't you responding to the court and your attorneys?
I don't check my voicemail.
Well, you're gonna check it now. You know why? You have too many felonies pending.
Right.
You're gonna check your phone. You're gonna call your attorney. You're gonna respond when the GPS tether people contact you. You're gonna respond when pretrial services contact you. It's time for you to be responsible so we can get through these legal matters without you having to sit you in jail so you can lose your job. I don't think you wanna lose your job. So then be responsible. Go pay your tether today. Your matter's scheduled for an exam on the 9th. Are we continuing to exam?
Yes, Your Honor.
You need to appear in person at 9 o'clock. I don't care if you get off work at 8:59. You gotta be here by 9.
Okay.
You understand that? Do you have any questions?
No.
Any additional matters for the record?
Nothing from the people.
Nothing additional on behalf of Mr. Bledsoe, Your Honor. Thank you.
I need information from the tether company today, within the next 2 hours, that you have paid and that you're back online. Otherwise, I'm revoking your bond. You'll be remanded until this matter is dissolved of, even if that's a bind over at the circuit court. Do you understand that?
All right. Yes.
You're all set.
Thank you, Judge.
Thank you. On the record in the matter of the people of the state of Michigan versus Jon Sherman Jr., file number 23-03161 FY, council appearance.
Yes, good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Gidget James on behalf of Jon Sherman, who was present at defense table, standing to my right.
Oh, today was the date that was set for a preliminary examination of domestic violence, unlawful imprisonment, assault with intent to do great bodily harm less than murder, assault with, or 2 counts of assault with intent to do great bodily harm less than murder, and a habitual offender fourth offense notice. How are we proceeding?
Your Honor, there's going to be a waiver of the examination today.
That's correct, Ms. James.
That is correct, Your Honor.
Is there an offer?
No, there is not. There's another file up at the circuit court. The plan is to do a global resolution across the files that will be negotiated once we're up at the circuit court.
That is correct.
Okay, Mr. Sherman, you understand that you have the right to have a preliminary examination in this matter in the district court. You understand that you have the right to require the prosecution to put forth evidence today that would be sufficient to establish probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You wish to unconditionally waive your preliminary examination? Anybody threatening you to do that?
No.
Any promises being made to get you to waive? And you understand that once this matter is bound over, you can't change your mind. So this matter will be sent to this circuit court without a hearing on probable cause. If you don't like your offer, once you get there, you've already waived. You recognize that?
Yes.
Bind over date's gonna be May 15th. That state circuit court gets the file from the district court. You do not need to appear in court on that date unless for some reason your attorney files a motion for you to be rearranged in circuit court, okay? Otherwise, your next court date will be a pre-trial in the circuit court. Your attorney will be made aware of that next court date, okay? What's your address?
1907 North High Street.
That's the address for the system. I don't know, it's okay for some reason.
Yeah, I just moved, but I've updated my address with the probation department and my lawyer. Are you up here?
Sounds good. And your phone number?
517-515-0413.
Was set at 50,000, 10%. With GPS tether and victim notification if possible. No contact order with the alleged victim, Nicole Delaney. That will all continue. Any additional matters for the record?
Not from the people, Your Honor.
Not from defense.
Thank you. You're all set.
Thank you.
Thank you.
We off the record?
Yes. sure how it's 2025. We still don't have anything. Let's see here.
This one, she's on the record in judge floors right now.
What's your name?
Nakia Nilly.
She might as well come at 2, because I think they're showing our down the system from 12 to 2.
I can see here.
Okay, ma'am, you're actually scheduled for 1:30, but they're shutting down our systems between 12 and 2, so you should come back at 2 o'clock.
Okay,
You're all set for now.
thank you.
You're welcome. on the record in the matter of the people of the state of Michigan versus Jon Michael Summers, file number 23-02864. Council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
So today is the date that is scheduled for a preliminary examination. Are we ready to proceed?
People are ready to proceed, John. Yes, sir.
Okay, any preliminary matters?
Nothing from the people.
Okay, you can call your witness.
Thank you. People first call Officer Ethan Mallett.
You can have a seat, sir. Sit right next to your attorney. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
Thank you. You can have a seat. State your first and last name and spell them both.
Ethan, ETHAN, Malik, MALEK.
City Council.
Thank you, Your Honor. Good morning, Officer Mallett. How are you doing?
I'm good.
Where are you currently employed?
The Lansing Police Department.
And what are your duties?
I am assigned to the Uniform Patrol Division
And how long have you been a police officer?
Since May 5th, 2023.
And so were you working as a police officer on September 15th, 2023?
I was.
And on that day, did you receive a call from dispatch?
I did, yes.
And what was that call from dispatch when you were working?
Dispatch toned it out as a weapons complaint. They stated that there was a black male subject behind the Happy Pizza that was waving a firearm around, pointing it in the area of where people were at and pointing it at parking spaces.
And so did you respond to that dispatch?
I did, yes.
What did you do first?
First, we went to the area where the call came out as and looked for the subject in that area where the call came out.
And from the information you received from dispatch for your investigation there, did you receive a description of the person with the firearm?
Yes, we received information that it was a black male wearing gray pants, a black shirt, and initially dispatch said that it was black boots, but then they updated it after initial information that it was tan work boots.
So after you went to the Happy's Pizza and didn't see a person there, or person matching that description there, what did you do next?
We traveled through the area. We received initial word from a caller that they headed toward the stadium at the corner of Michigan, which we knew was the Lugnut Stadium. So we traveled the area on the route that was consistent with that from the Happy's Pizza to the Lugnut Stadium.
And at any point when you were, I guess, looking for this individual, did you spot someone who matched the description you provided?
Yes, we located on Michigan Avenue near 8th and Home Street. We located a subject that matched the description.
And you located him where?
We initially observed in between 8th Street and Home Street on Michigan Avenue.
H Street?
8th.
8th, okay.
7, 8, 9,
Yep.
number 8. Okay.
Yep.
And when you initially spotted that individual by 8th Street, about how much time had passed from the initial dispatch call to when you saw that person?
It was approximately 18 minutes, I believe.
And so, while you were driving, looking for this individual. Did you see other people out and about that day?
We did.
And did those other people, did any of them also match the description?
They did not.
So after you spotted a person matching the description, what did you do next?
We made contact with the subject at the intersection of Michigan and Pennsylvania Avenue.
And about how long was it between you making contact with him at that location and the original dispatch?
That was the 18 minutes.
Oh, that was the,
Yep.
okay. And what was this individual wearing?
The individual we located had on gray pants, tan work boots. At the time, they had a black hoodie on, a black backpack, and a black surgical face mask covering their face.
And so when you spotted that person, did you immediately approach them, or did you wait a second? How did you handle the situation?
We observed them walking to make sure they matched the description and to see if we observed any signs indicating they might have had a weapon on them.
Okay. And from your observations, did you see any of those signs?
Yes, so the subject had their hand inside of their hoodie, and when they were walking, one arm was not freely swaying, which through training and experience, we know typically means they're holding on to something that is heavy, and that's why their arm is not swaying when they're walking.
So then after you observed this individual with the one hand in his pocket, what do you do next?
So we made contact with the individual at the corner of Michigan and Pennsylvania. We asked the subject to place hands behind his back so we could detain him and perform a carry pat down to see if the subject had any weapons on them.
And the intersection, the corner of Michigan and Pennsylvania, is that in the city of Lansing?
It is, yes.
Ingham County?
Yes.
State of Michigan?
Yes.
So, so you approach him and do you inform him that you want to pat him down?
Yes, we asked the subject to place his hands behind his back and told him that we were gonna pat him down for weapons.
And how did he respond?
He did not place his hands behind his back and attempted to initially walk away from us, which at that point we grabbed onto his arms, not allowing him to freely walk away.
And so then after, so I just want to make sure timeline is clear. So you inform him that you want to, you're going to pat him down. And then you give him a command at all?
Yes, we told him to put his hands behind his back multiple times.
Okay, and he did not do that.
He did not.
And what were you wearing at this time?
My full Lansing Police Department provided patrol uniform.
So after you said he starts to walk away and then you get a hold of him, what happens after that?
We attempted to get his arms placed behind his back so we could secure him to pat him down. He attempted to pull his arms away multiple times. We had to use strength and leverage to try and get his arms behind his back so that we could secure him. We initially were unable to do that. So myself and the other officers on scene took him to the ground to try and gain control of him to get him in a safe position where we could detain him.
And so you weren't the only officer who had responded to this situation.
That's correct.
Do you know how many officers ended up being at the Michigan and Pennsylvania intersection?
I know there was at least 4.
Okay. And so once Mr. Summers, once he's placed in handcuffs, during this process, are you able to see his face?
Once we got him onto the ground, yes, we were.
And would you recognize him if you saw him today?
Yes, I would.
Is he present in the courtroom?
Yes, he is.
Can you describe where he's located and article of his clothing?
He would be the male subject to my left in the front row there wearing the green jacket.
Thank you. I'll let the record reflect that Officer Malik has identified the defendant.
Any objections to identification?
Not for the purpose of putting the exam.
Identification noted.
Thank you, Your Honor. So, and did he provide his name to you at all?
He did not.
After he was detained, was he patted down?
He was, yes.
And did you observe that occurring?
I did, yes.
And can you describe what you observed happen?
I observed Officer Robertson begin patting him down, at which point she located a firearm on this person.
And could you see that firearm prior to him being patted down? Let me rephrase it. Was the gun visible outside of Mr. Summers' clothing?
It was not.
And then after being patted down, or excuse me, after Officer Robeson discovered the firearm, Were you able to observe what the firearm was?
I was, yes.
And could you describe it?
Yes, it was a black 6-hour 9mm handgun.
Where was the firearm located again?
The firearm was located through his belt loop in the appendix style on the front of his person.
And then after locating the firearm, what did you do then?
I assisted in controlling him while they removed the firearm. We had to cut the belt off due to the belt being through the trigger guard. So we removed the belt and were able to secure the firearm. We continued a search of the person. We did not locate anything aside from the firearm, at which point he was placed in my patrol car.
And then just one more question, sorry to loop back, but when you initially were observing the individual who matched the description and you said that he had one hand in the sweatshirt pocket, do you remember, is that like a hoodie sweatshirt where the pocket's in the center or more of a like a zipper sweatshirt where pockets are on the side?
It was a black hoodie with the pockets on the front.
Okay, so his hand would be towards the center of his body?
Correct, through the pocket on the front.
Okay. Further questions?
Cross-examination.
Thank you. Somebody, you said that you received a 911 call dispatch, correct?
Correct.
And describing a gentleman who was waving a handgun around Happy Pizza.
Correct.
Now, you said that the 911 call, when you observe my client matches the person that was described in the 911 call, correct?
Correct.
Now, the 911 call described the person wearing a gray shirt.
Correct.
Correct?
Correct.
You testified that my client was wearing a hoodie. Is that correct?
At the time of contact, he had a black
He was-
hoodie on over top, correct?
Yeah. So you could not see a gray shirt.
Not at the time of contact, no.
Okay. And the 911 call also described that he was wearing gray pants.
Correct.
And what was my client wearing?
Great pants.
Gray pants? The 911 call gray pants, they didn't describe the pants as sweatpants, correct?
My recollection is that they described them as gray pants.
Okay, and my client was wearing, let me show you something.
So exhibit.
Another exhibit, just look.
Are you refreshing his recollection? Well, you gotta tell me what you're doing first. Are you trying to refresh his recollection?
Yeah,
So I don't think he said he didn't remember.
I would like to, okay, I'm gonna to present this as an exhibit. Okay.
But he didn't say, oh, you are gonna present it as an exhibit. Okay, we can mark it.
Show you what is my exhibit, defense exhibit number 8. Can you see what my client's wearing?
Yes.
He's wearing sweatpants, correct?
Gray sweatpants, correct.
The 911 call also described the person wearing having short cut hair. Do you remember that?
I don't recall the description on the.
Okay. Do you mind if I can, if I play the?
Well, give me, okay, what was this proposed exhibit numbered as?
A.
Defense A?
Yes.
Are you making a motion to
A
admit
motion to
it?
admit it, yes.
Any objection?
Yes, Your Honor, just for lack of foundation, he has no knowledge of how this photograph was taken, or at
Agreed.
least no questions have been asked about how his knowledge of the photograph.
Agreed, you gotta lay some foundation in order for us to move forward.
Was were picture taken of my client that day? Part of the police report, you made a police report, you wrote a police report.
Correct.
Okay, and you said you assist on my client, in my client being arrested, correct?
Correct.
And you have a good recollection of what he was wearing?
Correct.
And at part, you usually generated a police report, correct?
I'm sorry?
You generated a police report.
I did.
Okay, and part of the police report has picture of my client.
Correct.
And I just show you one of the picture.
Correct.
And that what it, you said, you recognizing the picture, you said that he was wearing the gray pants, which was your recollection, correct?
Correct.
Do you recognize this picture? He's showing
I
the picture.
recognize it from the report, yes.
Is that the picture? Do you know who took the picture?
To my knowledge right now, I do not recall who took the picture.
Okay, well, does it look like the picture you attached to your report though?
The picture was attached to the report. I don't know if myself personally took the picture, if another officer took it, but it was attached to the report, yes.
Attached by you, correct? To the report?
So,
I'm just trying to see if it's attached to your report.
yes, so any officer can attach it, but yes, it was attached to this report, yes.
Okay, so I need to know if you're able to identify, you have to show him the exhibit. If this is accurate reflection of the picture as you remember it being attached, or if it appears to be altered.
That is accurate.
Okay, thank you. Any objection?
No objection, Your Honor.
I'm sorry, defense A is admitted. And then you had another question, I think, about it.
Now, the 911 call also describe the subject as having a short cut hair. Is that correct?
I don't have recollection on what the hair description was.
Now, if I play the police report, the 911 call, would that refresh your memory?
Sure.
Location of your emergency. 601 North Cedar Street, Riverfront Apartments. There's a black gentleman running around with a gun. What's he wearing? What color clothing? Gray everything. Tan work boots. He's got a black glove on. Short cut hair. He is an elderly gentleman. I want to say 40s, high 40s. 40s? High 40s. Inside or outside? He's outside. He's running around the park.
Are you able to answer my question now, sir?
The 911 call does have the original caller stating that he appears to have short hair.
Okay. Now, it also described the person as being elderly in late 40s, correct?
He described them as being late 40s, correct?
Okay. And also described the person as having a glove, a black glove on behind?
Correct.
Okay. Now, you testified that you had the opportunity to see a client's face. He had a face mask, correct?
Correct.
Now, the 911 call doesn't say that person was wearing a face mask. You agree with me?
To the point that you just played, correct.
Okay. And so the 911 call also described this as having short haircut. My client does not, this picture that I show you, that the exhibit, does not show someone with short haircut, correct?
I would say that's a matter of interpretation, dependent on short hair. Some might consider that to be short hair.
Okay. When my client was arrested, you did not see any gloves in his backpack or anywhere on him, correct?
He did not have a glove on at our contact, no.
Okay, you did not even see any black gloves in his backpack.
I'd have to refresh myself with my report on his prisoner property.
Okay. if you had found any black gloves as described in the 911 call, that's evidence that you would have put that in the police report. Do you agree with me?
Can you rephrase the question?
The 911 call described the person as having black gloves on, correct?
Correct.
Now, if you say someone who's matching the description given by 911 call, and you see the gloves, would you have marked that?
If he was, yes.
Okay. I'm going to show you, you wrote a report. We already established that you wrote a report after the incident, correct?
Correct.
And it was close to the incident that you wrote that report.
Correct.
And the reason is that, it takes time to go to court and you want a good recollection of what happened that day. Is that correct? When you write the report, you want to be as precise as possible so that you have a good recollection what you have to testify for.
Correct.
Okay, so I'm going to show you your report that was written by you on September 9th, 15. Let me give you a clean one because.
Are you refreshing his recollection on something?
I would like to, I'm going to have it as a day. I'm going to ask him the question. I'm going to ask him the question first. In your report, you don't give the description as stated as heard in the 911 call. Is that correct?
I do have a section of the report that details a description of the subject.
Okay. And when at the beginning of I'm going to show. So can you show me what part of the report you say has a description? Okay.
If I may, Your Honor, I can.
Yeah, hold on. I find it. Okay, when you met, let's forget about that question. When you met my client, and in your report, you describe him as wearing a black hoodie, correct?
Right.
Now, the 911 call did not say that he was wearing a black hoodie. Is that correct?
Correct.
You also described him as wearing gray pants. That's just the color, but you did not describe what kind of pants it was, a dress pants or sweatpants. Is that correct?
They were gray pants, correct.
Okay. And you said that he had a he was wearing 10 work boots.
Correct.
And he also had a gray black backpack, right?
Correct.
Now the 911 call does not say that the person described the person does not have a gray black backpack, correct?
The original 911 call did not, correct.
Okay. And he also said that he was wearing a surgical face mask. Your report that my client was wearing.
Correct.
And nothing the 911 call said that the person was wearing a face.
Not the original 911 call, no.
Okay. Now, you see a gentleman who's going his way and you stop him. You did not testify that you saw him do anything else, but the fact that he seemed to match the description by 911 call. Is that correct?
Objection, Your Honor. That's not what the testimony was. What the testimony was. He testified that he observed someone who matched the description of defendant, and then a description they received over dispatch, and then also he was observing him walking in a way that, based on his training and experience, suggested he had a handgun or had a firearm on his person.
He said he was walking with one hand in his hoodie. But I walk with my one hand in my hoodie sometimes. Does that mean that I have a handgun?
No, it does not. No, but also I would say that based on like the ongoing situation and circumstances, all of that taken into account, along with his training and experience, that's what he observed. It just wasn't just that he saw the person, it was that he also observed this others.
Correct, and so her line of question is that he made a stop of this person based on the description, or they believing that he fit the description and that he, I guess, had his hand in his pocket. Well, she didn't say that part, but she's stating that there was something else. I'm overruling the objection because I can see where she's going with the line of questioning. He can answer as to whether or not that miscategorizes his previous testimony, which I think the record does reflect. He did indicate one hand in the pocket, but I think her question is what she's trying to get to is, was there anything else that caused him to make a stop of this individual is what I think she's trying to find out.
So my question is, if you were not for the 911 call describing what you believe matched the description for 911 call, you would not stop.
If we did not receive a call for service, we would not have made contact with a random individual, correct?
Having a hand in a hoodie is not illegal when you're walking. Is that correct?
That is correct.
If you stop someone who believe, well, with your experience, you said it's been a year, almost a year since you're a police officer who's licensed in the police department.
Correct.
Well, do you have any other experience with another police department?
I worked for the Gratiot County Sheriff's Department prior to coming to Lansing, yes.
You cannot, when you see someone walking on the road, and if the person, will you be surprised if the person has not committed any crime, that the person will resist if you try to stop them?
Can you ask the question again?
You don't stop anyone. When people are walking, you just don't stop them, correct? You don't stop people randomly.
That is correct.
Okay. And as a police officer, you cannot, your action has to be lawful. Is that correct?
That's correct.
I have no further questions, Your Honor.
So redirect.
Yeah, just a few questions. So Ms. Wanji played one 911 call that dispatch received on September 15th. Did 911 receive just that single call?
I'm not sure exactly how many calls they received.
And when you're saying calls, is it your recollection? Were there multiple calls? Was it just the one, or do you have no idea?
Without reading, I could not recall exactly.
And then when the once police had defendant's identity, or I should ask, you in the report state that you were the person, one of the officers who brought defendant to lockup.
That's correct.
At lockup, is that when you were able to determine defendant's identity?
Yes.
Okay. And did you search his name in any sort of database at that time?
I'd have to read through my report to see exactly what he searched through, but I would believe so, yes.
To the best of your recollection, did he have a CPL?
He did not, no.
And do you remember, so he's wearing the black hoodie on top. Do you remember if he was wearing something underneath it?
Not really, not recall.
And so when you were, prior to locating defendant, you said that you had seen other people out and about on the streets.
Correct.
Did you see other black men on the street?
I did, yes.
Did you see other white men on the street?
I did, yes.
Did you see other black women on the street?
I did see other varieties of people, yes.
And did you stop any of those people?
We did not,
And why not?
because none of them matched the clothing description that was provided, and with my training and experience, none of them resemble the person who might be displaying, exhibiting actions or traits consistent with someone having a firearm on them.
No further questions.
Okay, I have some questions. Did the suspect that you took into custody, did he have on tan work boots?
He did, yes.
Okay, what other than the gray sweatpants and the tan work boots was he wearing that caused him to fit the description?
I believe other officers spoke with witnesses in the area who described the black.
Objection, objection.
Objection sustained. Oh, my question was as to you. You said you stopped him because he fit the description, which was a black male wearing a gray shirt, gray pants, tan work boots. I think it was something about a black glove, maybe, and elderly in their 40s. What about this suspect, other than the gray pants and the tan work boots, caused you to believe that that fit the description?
Also the fact that the subject was a black male, the area we located the subject, the time frame that it had been consistent with when the dispatch call received. We put that into Google Maps, and the times were within 1 minute that it would have taken a subject to walk from the area the call came in to the area we located the subject.
Oh, and so just for the knowledge for the court, if you were to get a dispatch and they give the description such as they gave on the date and time in question, in this case, black male wearing a gray shirt, gray pants, tan work boots, and then you find someone within the area and all you can identify on that suspect, let's say it's just they have gray pants, but they don't have the other, you can't see them with a gray shirt or gray or tan boots. Would that still be sufficient enough for you to make a stop?
I believe we act on reasonable suspicion with everything included. So I believe in this one, the area the subject was located, the time frame, the actions, and the description altogether gave us enough for this situation.
Sounds good, thank you. Any cross-examination or redirect based on my question?
No, Your Honor, thank you.
No, Your Honor.
Thank you. May this officer be excused?
Yes, he may.
Thank you, Officer Malik. Thank you, Your Honor. You call your next witness.
So no, you're good to go.
thank you.
You can just let Rose in.
Thank you.
No, we won't be calling any additional witnesses.
Thank you. Is the defense calling any witnesses today?
Oh, no, Your Honor, thank you.
Okay, you can proceed to argument.
First, I just want to briefly say, Officer Malik's testimony was pretty to the point, and I think that the primary argument is going to come down to not necessarily whether the elements in this case were met, which I believe that the testimony, without me, belittling the point, basically, that the elements for both the charge of the carrying a concealed weapon and as well as the resisting and obstructing a police officer, the elements for those charges, the date and venue and identification were all met to a probable cause standard by Officer Malik's testimony. I think biggest potential issue with this case is the validity of the stop and pat down of Mr. Summers. Under People v. Taylor, which is a Court of Appeals Michigan decision, and I have the site if you'd like it. This case addresses a very similar issue. First, an officer, or to justify an investigative stop or what is considered a Terry stop, an officer has to have a particularized suspicion based on an objective observation that the person has been, is, or about to be engaged in some type of criminal activity. And it has to derive from the police officer's assessment of the totality of the circumstances. And in weapons instances, it is if he has a reasonable suspicion that the individual is basically carrying a dangerous weapon on their person. In this instance, Officer Malik testified that he did have reasonable suspicion. He observed other people out and about in the area between where the defendant was located and where the call initially came in. Those people did not cause him to develop reasonable suspicion about them being engaged in any type of criminal activity, because they did not meet enough of the descriptive factors from the dispatch information of the suspect. Officer Malik testified that defendant was the only individual that they saw who, to his recollection, had the gray pants and the brown boots on. I for sure can understand some concerns about maybe the age not being the same. You know, obviously, defendant sitting here is not a.
I don't have any concerns. I mean, the caller said it was elderly and 40, so my concern is with the caller, because our 40 is not elderly.
Yeah, and I would just in response to that, I would just say that Officer Malik, you know, his they are going off of imperfect information. They're receiving information as the situation is ongoing. They're responding to a potential weapons complaint where someone is pointing a firearm in public, and so based on the fact that of the location for where the individual, or where Mr. Summers was spotted in relation to the initial incident, along with the corroboration between the pants and the boots, as well as his observations of Mr. Summers having his hand in the center pocket of his hoodie, which would be located directly over where the firearm was found. While obviously each of those individual facts in isolation would not reach a reasonable suspicion standard, those would just be random things you observe in your day-to-day life and that officers observe all the time. But all of those factors taken in the totality of the circumstances, those in and of themselves provide reasonable suspicion. And because of the facts of the case, that someone was brandishing a firearm, and then he also saw someone walking in a way he understood to be consistent with someone who was holding a firearm, that would cause Officer Malik to have reasonable suspicion that that Mr. Summers is in fact potentially armed and dangerous, and thus a Terry pat or a pat down situation would be admissible in lawful conduct by the officer.
Thank you. Ms. Lange.
You know, on the actions of this police officer, any black person would be arrested. The 911 call was very clear, and that's what prompted their actions. The person was wearing a gray shirt. McClellan was wearing hoodies, and not even black hoodies, not even gray shirt. He was wearing black hoodies. McClellan was wearing the person said was wearing 10 pants, boots. That's the only thing that McClellan was, that matches the description.
I thought he was wearing gray pants.
No, gray pants were gray pants, the way I see it, he did not say sweatpants.
How does that say sweatpants? It said gray pants.
Okay, well,
maybe the suspect has blurry eye vision and they couldn't see. I don't know. Maybe they didn't recognize them to be sweatpants, just knew that they were gray. Doesn't matter. They didn't describe it. It'd be one thing if the caller said the person is wearing some gray dress pants, and then they see someone with gray sweatpants, then maybe they're a little off, or maybe the collar's off. That happens all the time. I am convinced that I heard the call when you played it for the recollection of the officer. I'm convinced that the person who called probably was saying what they thought they saw, but just based on the mere fact that they said 40-year-old elderly and then 40-year-old, that struck me as a very clear concern that maybe this person doesn't know how to give a description in general.
Well, they say elderly gentleman, elderly black man, gentleman, late 40s, gray everything, 10 boots.
Definitely said that.
Okay, so nothing but beside the boots and the gray pants. Nothing matches my client. He doesn't have gloves on him. He doesn't have, my client has a backpack. That person did not have a backpack. He was not described as having a backpack. And my client was going on his way, minding his business, walking, and the police stopped him. This is America still. They don't stop you for nothing. Well, they try to, like here. Beside the fact that if it were not the 911 call or what my client, the police officer prescribed being my client matching, I don't see anything that matches that person. That the description, or actually for me, any other person would have matched they would have been arrested. 10 boot is very, very people. It's common. People like to wear 10 boots. So I'm not surprised that my client had his 10 boots and the person they also described the person having a mask. It did not describe the person as having a mask on the face. My client did have a mask. If the person had a mask, I'm sure that the 911 call person would have not been able to say, oh, elderly 40. So I do believe that this is the actions, the stop was not legal. The action of the police officer was not justified. So I would ask the court to dismiss the case.
Thank you. Today was a date set for a preliminary exam, and the burden is on the prosecution to establish sufficient probable cause that a crime was committed and probable cause sufficient to charge you, Mr. Summers, with the crime in this case. Count 1, carrying a concealed weapon. Count 2, police officer assaulting, resisting, obstructing. This is not a trial. They do not have to prove each element beyond a reasonable doubt. This is more than mere suspicion is the burden. So it's a pretty low burden of proof at this stage of the prosecution. I have testimony here from Officer Ethan Malik. The court will be the sole determiner of credibility of the witness, which I found him to be a rather credible witness. He testified that he had been an officer about 3 days short of 1 year. At the time of September 5th, 2023, he was on patrol and he received a dispatch. He stated for a weapons complaint of a suspect at behind the Happy's Pizza waving a gun around. He stated the area or the location of the individual first matching the description between 8th Street and Holmes, City of Lansing, Ingham County, State of Michigan. The dispatch, which Ms. Wangji so kindly reminded or refreshed the witness's recollection, had a caller calling 911, giving the description of the suspect as a Black male. I think he said shortcut hair, wearing gray shirt, gray pants, tan work boots, and that he was observed raping a gun around. I also want to put on the record that no one ever gave me the exhibit that was admitted, the picture. You take it.
Function's the same, but it is a different photo.
He may have confiscated them. They left because I'm sitting there. Oh, you have it? Oh, okay. Thank you. Okay, and so again, the description was a Black male, short hair, short cut hair, wearing gray shirt, gray everything, gray pants, tan work boots. No mention of a book bag, no mention of a mask. Officers locate and make contact with a suspect that they believe fit the description. I think he stated at this point, the contact was made at the area of the corner of Michigan and Penn, Pennsylvania, City of Lansing, Ingham County, State of Michigan. Officer indicated that the individual they stopped had on a Black hoodie, gray pants, gray sweatpants to be specific, some tan boots, a Black mask, that the individual was walking. He had one hand inside of his hoodie, which the officer believes, based on his training and experience, which I want to preface experience being limited because he's not even been an officer a year yet, is an indication of the likelihood of carrying a weapon or firearm, because one hand was in the arm, the other, I guess, swinging in a specific way, or arm not swinging, and it appeared that he was possibly holding something in his pocket. And so officers stop the suspect. They request or ask to do or perform a Terry or investigative pat down search of the person. They stated that the defendant or the suspect was asked to place his hands behind his back. Officers attempted to place the suspect's arms behind his back, and the suspect at this point resisted. Officers had to eventually get the suspect onto the ground to secure him due to the resistance after being given a lawful command. Officer testified that he was in his fully marked uniform during this interaction. He stated that Officer Roberson, in his presence, performed a pat down and located a firearm in the belt loop. He indicated the belt needed to be cut, I think, to retrieve the firearm. A firearm was not, that he described as a black 9mm, was not readily visible to the public the way it was located on the person of the suspect. He said the suspect did not give his name, but when taken to lockup, they did make a determination as to what the individual's name was. He identified the individual as the person seated in court here today, Mr. Jon Summers. When specifically questioned about whether or not Mr. Summers would fit the description, he gave further clarification information as to the investigation also yielding information, or that they're going into a Google search to see if the place where they're locating this person who has on the gray pants and gray boots is within a certain minute radius of where the alleged incident occurred. And he believed that this suspect was within that radius, within a 1 minute radius, and it would have been consistent with the time frame of the alleged dispatch. In order to prove count 1 of weapons carrying concealed, people would need to prove beyond a reasonable doubt first that the defendant knowingly carried a pistol. It does not matter why the defendant was carrying a pistol, but to be guilty of the crime, the defendant must have known that he was carrying a pistol. Second, the pistol was concealed on or about the person of the defendant. Complete invisibility is not required. A pistol is concealed if it cannot easily be seen by those who come into ordinary contact with the defendant. Again, the officer indicated that the way in which the firearm was located in this particular instance was not readily available. He did also readily visible, I should say, and he did not, the defendant did not have a CPL to the best of this officer's knowledge and information. Ms. Wangi Defense Counsel is making the argument that the stop was unlawful and that the officers did not have sufficient information to stop this individual as a suspect, that any individual, any Black male could have been subject to being stopped in this area. The court tends to disagree with that because I understand that the defendant or the suspect that was stopped, at least in this picture, it could be black, it could be dark gray. I really can't tell what color this hoodie is. I don't know what he had on under there, but this individual does have on gray pants and tan boots. And this incident having occurred September 5th, 2023, in the middle of the summer. Not a lot of people wear tan sweatpants and work boots within a 1 minute radius of where this alleged incident occurred. I recognize that there was no description given of someone wearing a mask, but it's very easy to put on a mask if you were trying to maybe disguise what you look like. So that is a possibility. And officers would need to flush that out, which is why they do investigative stops. That's the purpose of an investigative stop. And so if you find someone, and I also want to address the hair situation, because that was a question, I thought it was a good question as to whether or not this individual's hair fit that description, because the caller indicated that it was someone with a short cut hair. The defendant that's sitting in this courtroom and the person who's in this photo does not have short-cut hair. However, the officer testified that that is left up to interpretation. And I think that interpretation is really a cultural issue. I can look at this Black man's hair. His hair is very natural. I can tell you what curl type he has because I'm a Black woman with natural hair. I can tell you that his hair is not short. It's shrunken because Black people's hair shrinks when it's in its natural state. But if his hair was stretched, his hair probably passes his shoulders. And so I don't expect that someone who doesn't have that cultural knowledge or experience to be able to identify that. However, I also have an issue where we have a caller who also referred to the individual as a elderly man and then described him to be about his 40s, which I don't believe the suspect is either in his 40s, at least not based on the information I have. He's definitely doesn't appear to be an elderly man to me, but what I have here is a circumstance where the caller, I don't know how close or far they were from the individual. I don't know what their eyesight was, but they're given an imperfect description, which happens often. But there are several factors that are still present in this case, that being the location of this suspect from the incident within the time frame relatively close to the incident, and officers indicating that this was about a 1-minute walk from where that location was, and given the time in which the alleged incident occurred and the time in which the officers made contact with the suspect, they found that to be consistent. We also have an officer who finds someone who has on tan boots with gray pants and one hand in their pocket, a hoodie pocket, which officers seem to believe is information that would tend to lead to the understanding that this person may be concealing something in their pocket. So if the court looks at the totality of the circumstances, the court does believe that there was a reasonable suspicion for a investigatory stop based on what the officer is telling us, and that there is sufficient probable cause as to count 1 based on that stop, because they did locate a firearm and that there was no valid CPL. So count 1 will be bound over to the circuit court. Count 2 is police officer assaulting, resisting, obstructing, and the people would need to prove beyond a reasonable doubt at trial that the defendant did assault, batter, wound, resist, obstruct, or oppose officer Ethan Malik, a police officer from the Lansing Police Department that the defendant knew or had reason to know was performing his duties. And the officer, again, given testimony that on this date and time in question, when he made contact with the suspect at the area of Pennsylvania and the corner of Michigan, that he did request or make a lawful command to the suspect that he was going to perform a Terry stop, and that the defendant was to, or suspect was to place his hands behind his back. Officers testified that the defendant was resistant, that they attempted to try to place his hands behind his back, and that there was further resistance, and that the suspect had to be taken to the ground in order to secure him before an investigatory search could be conducted. Based on that testimony as well, the court is satisfied that there's sufficient probable cause as to count 2. So count 1 and 2 will both be bound over to the circuit court for further prosecution. Your bind over date is going to be May 15th. That is just the date that the circuit court will receive the file from the district court. That is not the date that you need to appear in court unless your attorney makes a motion for you to be rearranged at the circuit court, okay? The next court date will be a pretrial, and your attorney will be made aware of that. Any additional matters for today's record?
Nothing for the people.
Nothing, Your Honor. Thank you.
Thank you. You're all set.
Patty, can I get a transcript request for that? Yeah, thank you.
Did you need us? Oh.